on the existing protocol well established by our Sheikh and previous speakers for the ones of time. The title of this session, this panel session, is Hidden Wealth, Informal Investments, Digital Assets, and FinTech Investment, Cooperative and Family Contributions in Islamic Inheritance. How are they being dealt with? Mine is just to establish a background for the presentation so that the panelists who are intentionally being selected and are expert in their various capacities will, inshallah, deliberate on it. Islamic law of inheritance, known as Fara'id, is ordained system governing the devolution of a deceased Muslim estate. It is not a discretionary or customary agreement, but a mandatory legal system established by Quran and elaborated as well by Sunnah and being systematized by Islamic jurisprudence, the fiqh. Unlike the man-made inheritance system or system of succession, Islamic inheritance is rooted explicitly in the Holy Quran with specific reference to Surah An-Nisa, chapter 4, verse 11, 12, and 176, where Allah subhanahu wa ta'ala specifies the eligible heirs, also fixtures and principles of distribution, how these are going to be distributed. And as well, our ground norm of this country, the Constitution of Federal Republic of Nigeria, well recognized in section 275 to 79, the Islamic system of inheritance under what is known as Islamic personal law. So also, under the residual list of legislation, states, assemblies, and state governments are being empowered by law to establish laws and regulate the Islamic law of inheritance as part of the concurrent list of legislation. We have a lot of law cases which previously there was this notion that Islamic law of inheritance is also a customary law, as is being established in the case of Inusa versus Adesobokon, where it was subsequently been ratified in the cases that have been considered as locus classicus in Islamic law of inheritance, the case of Ajibaye versus Ajibaye, the case of Alkamawa versus Bello, and the likes were very good decided cases on this. So also Land Use Act and the Company and Allied Matters Act and ISA Investment and Securities Act, under which corporate trustees are being empowered to hold assets and manage them in trust in their corporate capacities, sometimes for perpetual succession. And as well, as corporate trustees such as Alamin trustees, such as First trustees and others can take the mantle of distribution of inheritance if they are being assigned by the person involved as ordained by the law. So. Can you move manually, please? So in Islamic law of inheritance, inheritance just doesn't come like this, just by discretion of the owner of the asset. Rather, Allah subhanahu wa ta'ala has made it explicit that there are designated persons based on some designated relationship that are regarded as legal heirs. The causes of inheritance in Islamic law of inheritance are three. The first one is marriage affinity, that is the wife and husband, the spouse, one another they can be inherited. We have blood relationship, which include the origin of a person, that is the root, the parents of the parents, and their parents, no matter how low. So also we have the branches which are considered as the offspring, the children, and the children of the children. They are also part of the inheritance. And as well, we have the nearby relatives who are regarded as brothers, cousins, uncles. All these are nearby relatives, and the cause is affinity, is the blood and consanguinity relationship. The next is the clientage, where any person who is deemed to be a slave and being freed by one person, if he has no any other heir, his master is entitled to whatever he left as inheritance. Next slide, please. These are the causes of inheritance, and whatever deceased left is attributed to some certain rights in Islam. One of there are notably 4 rights. First is the funeral expenses. If it requires that there is need for some expenses for the funeral of arrangements of the deceased, it is allowed Islamically to be used, and that one must be restricted to Islamic funeral rites, not any traditional, talk less of extravagant spendings in the name of funeral expenses. So also settlement of debts. The debts could be by the creator of Allah subhanahu wa ta'ala, or those by the creators who are the normal human being. فَدَيْنُ أَوْلَى بِالْقَضَاء, as it comes in one hadith. You have to settle the rights like zakat, like nudur and others before you talk of the debts of others. And wherever it suffers adoption, that means it is stopped, will not move to the next. The next is the execution of will, which has been discussed by the previous speakers, which must be restricted to 1/3 and must be within the Sharia compliant areas. And as well, the last but not the least is to be shared in inheritance. This arrangement could be given. That means somebody can write his will stating all these arrangements and how it will be used, and entrusting a corporate trustee to take care of it to avoid any dispute. Next slide, please. Therefore, the concept of tarika, which is the estate of a deceased person in Islamic law, refers to everything that a deceased person leaves behind and that is legally attributable to him at the time of his death. And as well, whether visible or hidden, tangible or intangible, they are all part of it, whether documented or undocumented. This means tarika is not limited to physical property or bank branches, balances, but extends to all forms of wealth, benefits, and enforceable rights. And we can look at it, next slides, we can look at it from about 2 different divisions. We have tangible assets, which includes landed assets, cash valuables, movable property, merchandise, and inventories. The second category is the intangible assets, which includes debt owed to the deceased, investment interest and profit shares, digital assets and account balances, cooperative contributions and entitlements, as well as the intellectual and contractual rights. All these are part of the tarika, and they can be inherited according to the Islamic law of inheritance. And when we talk about the hidden wealth in Islamic law of inheritance, which the modern time brought about, in many Muslim families, substantial portion of wealth exists outside formal banking and investment system. These assets, often referred to as hidden wealth, which includes formal investments, digital and fintech-based assets, cooperative society contributions, rotating savings schemes, family businesses and interests, as well as the undocumented financial support arrangements. All these are considered part of the modern hidden wealth that many people don't care about, which in most cases suffers adoption because you don't provide access to them so that your ears are unaware of them, talk less of being dividing them or distributing them in inheritance in accordance to the Islamic law of inheritance. As technology and financial innovation expands, new asset classes as cryptocurrencies, digital wallets, investments apps, crowdfunding platforms, and fintech savings schemes are becoming increasingly common. Unfortunately, these assets are frequently excluded from estate plans due to the lack of documentations, awareness, and understanding of their Sharia treatment. And this is the major focus of this particular panel, to discuss the ways through which people can utilize the corporate trustees and other legal means to document and make available this hidden wealth. And I will stop here for once some time. Thank you very much. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Thank you very much, Bob, for that very concise and elaborate presentation. Before I go to the panelists, I would like to make a very brief comment on the position of Islamic law in customary law, like you have stated. Now, those decisions were made over 30 years ago, and I'm very excited about the new judicial position taken by the Court of Appeal last year. In that decision, two of them actually, the Court of Appeal held that Islamic law is not customary law.
Yes.
And they were very specific by saying that customary law is largely undocumented and they vary from community to community. But Islamic law, beyond being universal, is documented. And interestingly, that decision was taken in an estate dispute litigation that started from Kwara State Area Court to Kwara State Sharia Court of Appeal, and then eventually the Sharia Court of Appeal. So in that decision, the military man, who started his military career in Jos, got married to his first wife, who was a Christian, under the Act. That military marriage. Eventually, he was posted out of Plateau, and then he took subsequent wives under Islam. Now, upon his demise, the first wife contended that being the wife married under the Act, to the exclusion of the other wives, she is entitled to his estate in accordance with the Marriage Act. When his benefits were paid, she refused to share with them. So when the family mediation process broke down, they now had to go to court. The court that tried the matter said, look, yes, he married under the Act, the marriage is valid, but he cannot be said to have contracted away his right to have his estate distributed under the Sharia. Because of that, the assets should be presented for distribution. And the argument kept going, look, the Marriage Act is very clear, Islamic law, Sharia law, because of that, the Marriage Act will supersede. You know, the Sharia Court of Appeal incidentally agreed with that argument until it went to the Court of Appeal. And the Court of Appeal said, no, Islamic law is not customary. Islamic law, beyond being universal, is well documented. And even though a man is married under the Act, he has no right, he has no legal powers to have said to contract out the right to either take a subsequent wife or have his estate determined under Islamic law. I understand that those decisions are currently before the Supreme Court. So we wait carefully to see how the Supreme Court will eventually decide the matter. But that being said, this panel fundamentally is supposed to focus on hidden wealth and all of this. So I will start this conversation with Professor Adam again. Sir, can you briefly tell us, you know, we are accustomed to, I leave this house there, I leave this land there, I leave the money in this account there. How do we, within Islamic estate planning structure, deal with, you know, this particular assets, cryptocurrencies, NFTs. You know, there are things of value. In fact, even monetized social media accounts are assets, right? So within the Islamic framework, how do we deal with them in terms of estate planning? Are there specific Islamic rulings on them? And how to go about them at that level? Thank you.
Thank you very much for this question. As I earlier alluded to this, in Islam, the concept of tarika, that is the estate of a deceased person, is well encompassing. It includes the tangible and non tangible assets, be it the landed asset, the movable and immovable assets, the cash that are physical, the cash that are in the bank accounts that are accessible, as well as the other assets that are not seen or that are intangible in its nature, like intellectual rights. Somebody has a book he published, that particular right he has in that book is also inheritable. It can be disposed, it can be transferred, it can be shared or be maintained, and whatever proceed comes out of it, it will be continuously being shared to the ears of that particular deceased, and it can pass through the generations. And it also includes the digital assets we are having under the new innovations and technologies, which includes crypto, digital assets, and the likes. All these Islamically are considered to be part of the Islamic estate in Islamic law of inheritance. And the way they are treated, Islam asks us or ordained us to preserve whatever we have of wealth. Therefore, whoever is owning this type of assets must make sure that he made provisions as provided within the regulated organizations or external regulating organizations, that whatever you leave after your death is going to be passed through your ears. What is our duty is to make sure that we follow whatever step is required, and sometimes we make some deliberate steps in order to make alternative access. We can document in some catalog, we can make lists of our digital assets so that our ears will know. There are a lot of unclaimed assets that are lost, that cannot be even traced to their owners after their death, simply because they could not do the right thing at the right time during their lifetime. Therefore, this is the Islamic position. Wallahu ala wa ala.
Thank you very much, Prof. I will come to you, Mr. Ismail. In terms of practical strategies, right? How do we make it easy? How do we integrate this not so real assets into our day-to-day estate planning? What are those practical steps we can take rather, to ensure that, yes, by their nature they are undocumented? How do you begin to document? How do you begin to assign? How do you make sure that they are available for distribution to us when a disease estate is being considered? Thank you.
Assalamu alaikum. Thank you very much for the question. So I'll be speaking from the side of the financial advisor side. I think we are used to seeing institutions being audited on an annual individual. I don't think most of us consider our wealth, investment, or property establish your liability and also your asset. For instance, for you to even pay zakat, you need someone who has good understanding of the investment industry for you to calculate what are some of the assets you have, what form of those assets is zakatable or not. And I think it gives you the opportunity to be able to have an holistic overview of the total assets you have in your custody. Yes, the value changes over time. However, there will be a cut-off period or a particular commencement period that will show the total ownership of assets you have, be it digital or tangible asset. And as such, it gives you the opportunity to establish those that are in the informal sectors, those that are in the formal sectors. And I believe by the time you now involve a regulated trustees to also come and provide such kind of services, it makes life easy for you. If you are owing some zakat that you need to pay maybe for a few years back, they will also advise you on how to make those kind of payments, so that you know that going forward, all your liabilities have been fully paid. What you now have on ground is your asset, and those assets cannot be subjected to how you want it to be managed. So I think the major thing is for us individually to have an audit of all our investment and everything we have that can be monetized, so that it gives us that foundation on that. Thank you very much.
Thank you very much. Mr. Obendi, please. I will come to you now with the same question. I will only add a layer to it, which is these assets, by their very nature, are very susceptible to laws. They are accessible to being unclaimed, by heirs who probably, due to their nature of being undocumented, don't even know they exist. So in addition to the question I asked Mr. Ismail, how do we mitigate? How do we mitigate?
Thank you very much. So my simple recommendation is have an estate plan and use an institution to help you create that plan. Now, why do I say that? I talked about unclaimed assets, which is part of the question you have asked. The UK government on a regular basis provides a list of dead Nigerians and other Africans that have assets in the UK, and nobody has been able to claim it. The good thing is that in Nigeria we don't have it. Now, because we don't have it, it then means that nobody knows. Imagine real estate, the one I buy in my name, maybe I did not tell my wife. If I pass, she will not know. That's real estate that is tangible. Then imagine I then have cryptocurrency. I'm the only one that has the password. That password will most likely die with me. Imagine if, and by the time it happens, you have created benefit for the organization. Because number one, the organization will not even know who your family members are. Unfortunately, you probably do not have an hours here. So like Richard said, there's no listing of your assets. You then also don't have work. You have created wealth for a company that nobody knows. Because most of these fintech companies probably are not in Nigeria. Your experience, your expertise in managing those digital assets we just finish with you. There's no wealth transfer to the next generation. So if a large chunk of your assets are then digital assets, you have then unfortunately created poverty for your beneficiaries. And that's why I say, have an estate plan. If you ask me, best thing to do is have a trust. All of these investments that you are making in your name, you can actually make those investments through your trust. You will bypass probate eventually because you will not pay 10% of the value of your assets to the state government if you have a trust. Plus the fact that your beneficiaries will then know what you have left for them, because part of the trust arrangement, there are three important parties, maybe four. The person creating the trust, which is you. The institution managing the trust, which is First Trustees and Alamy, and the beneficiaries. The beneficiaries are the people that you list out as beneficiaries. You then include the fact that even your grandchildren and great-grandchildren can also be added as beneficiaries. So if anything then happens to you, the institution continues to manage your assets. You have provided guidelines as to how it will be managed for your beneficiary. So in that particular case, sir, assets will not be lost because there's a record, there's an institution managing it, and there are identifiable beneficiaries that will then enjoy the full benefit of the digital assets that you have spent your life acquiring and managing by yourself. Simple solution: create a trust, have an institution manage it, and make all of your investments through that instrument of the trust.
Thank you very much, sir. Thank you for that very elaborate response. I will take this question to Professor Adam. Sir, we all understand, it is always emphasized, plan your estate because of your beneficiaries, your heirs, your children, and like some people will say, so that village uncles and aunties will not come and take it away from them. But in reality, does estate planning really means that you exclude people who ordinarily benefit from your wealth, from participating in it after, a man or a woman has passed? So, in practical terms, very quickly. Because you have a brother or a disease has a brother who is in the village, for example, and who is accustomed to supporting while he's alive, does it mean that when the man passes, that brother or sister who is accustomed to supporting, automatically ceases to benefit from his estate? The second question, which is closely tied to this, estate planning, yes, it helps you make arrangements for your children, your heirs, and all of that. Are there no other goals that can be achieved through estate planning beyond just catering for your children and your goals? Lastly, in doing that, can we use these assets or this hidden wealth to achieve those goals?
3 in 1.
Yes, sir.
Thank you for these loaded questions. Actually, to respond to the first question is to the contrary. When you talk of estate planning, it assists in inclusive beneficiaries, because it is through the estate planning that you have a well-structured, and you will also be guided by experts who knows this system. And through this, you can make provisions for the unforeseen situations that may happen to your children, even with what you leave for them. We have seen instances where children are being left with hundreds of houses and billions of estate, but at the end of it, they squandered it because they don't know its expense, and at the end of it, they become beggars and bottling to pay their school fees. And in some instances, they even squander the funds or the inheritance of the younger ones. In my personal experience of about 20 years of teaching and practice of Islamic law of inheritance, we have a lot of practical experiences. We've seen situations whereby people are alive, but their heirs or their to-be heirs are trying to dispose of their assets. We have seen situations whereby parents are quarreling with their children because the parents decided to do something with their wealth. So also we've seen situations whereby parents, sometimes the heirs, are even quarreling before the death on anticipation. I have this story that I used to tell in most cases. An elder statesman in this country was in hospital in London. His elderly mother is in Kano, was in Kano at that time. His brothers are hoping that this elder statesman dies before the mother, simply because of one overseas that is being allotted by Sharia. And his children are there quarreling and wishing that that old woman, their grandmother, the mother of their father, dies before their father, so that they will have 100% under their control between them and their mother. And this led to even hiring a private security outlet to come and provide 4 security men in full service, one in front of the room of the hospital and another inside, to be shifting 12 hourly. And this is because just they are thinking that the money that is there is very huge and they can do whatever possible. And at the end of it becomes a very contending issue between, because the mother of course died before the Alhaji, big Alhaji, who has a lot of wealth within and outside the country, and his brothers were very happy because their brother died before their mother. And luckily to them, according to them, the mother dies less than a month. So now they have 1/6 from their mother, and that children are taking the 1/5. And whenever an asset is disposed, our people lawyers will have to come and take the part of the dispute so that at least they get business out of it. So what I'm trying to put here is that through estate planning, you can avoid all this business because it's going to be managed through experts, and you can even have an opportunity to serve other purposes, particularly those people, those younger ones, those younger brothers of that deceased person that are battling to make sure that he dies before their mother. Had it been he has taken care of them through his will, Allah subhanahu wa ta'ala made this for us that we can make will up to 1/3. The Prophet sallallahu alayhi wa sallam in a hadith of Ibn Hibban said, Inna Allah tasaddaqa alaykum bithuluthi amwalikum ba'da mawtikum ziyadatan fi hasanatikum. It's an avenue through which you can use and do good to others who may even remember you more than your parents, more than your real children, because you make them busy with the money that you left. Therefore, you can achieve this, and you can also achieve what I usually tag as your Lahira savings account. Your hereafter savings account will be taken care of through estate planning. If you have a well-structured estate planning, you will be advised to at least take something in will to be your work, so that you will be crediting, you will be getting credits of alerts while in your graveyard, and it will assist you in the day of judgment. Wallahu ala wa ala.
Thank you very much, sir. Mr. Obedu, from the response, it appears you are very familiar with some of these instances. Very briefly, do you have anything to say to it for?
I think that if we really want to do ourselves the word of favor, is to just ensure that we have a plan, and that plan should be specific. So he talked about a story where people were praying that the man dies. There's a perfect example of, I think, the richest person in Ghana when he was on a sick bed, and with 3 wives, plenty children. On social media, you could see clearly that they were already fighting. So, apart from us saying that we want to be able to take care of beneficiaries that are well known, you need to avoid crisis. And crisis takes a whole lot of time and reduces the value of the assets in many ways. Look at the example that you gave. So they've gone from magistrate court to high court, appeal court, they go to Supreme Court. What I read was that because it was cash assets, the Christian wife and her daughter had finished the money, but the case is still in court. Maybe it's not me saying it. Maybe before they will finish the case, there will not be anybody to even pay balances if there's any balance at all to be paid. So you must avoid crisis. You must also avoid mismanagement, which he spoke about. Many of us have trained our children to go to school, but we have not trained them financially. We have also not disciplined them financially. For many of us, whatever our children ask us, we give them 2 or 3 of what they have asked us. They have the best of life. And we do it unconsciously, some of us suffer. So while I was going to school, it was only rice or if I was eating. My kids cannot suffer like me. So they will go on vacations every time. And they don't think it's a right. So discipline is very, very key. And the final thing I will say that in all your planning, because this is Nigeria and this is Africa, never ever assume that your siblings will take care of your family. You need to take care of your family by yourself, for yourself. Because the first thing that will happen, and I know that we are in an Islamic setting where the laws are there. Unfortunately, if your children are still minors, they don't have power. If you have trained them very well, they cannot fight, so they will not fight. Unfortunately, your wife or wives cannot stand your family members. They will first collect what they want to collect. By the time they now go to court, it's a different ball game altogether. So I appeal to you, avoid crisis. Take care of your family members, plan for them. In fact, whatever you want to do, do it for them, so that they will leave your family alone. And lastly, this matter, tax, you have to plan for it. You have to plan for it, so that at the end of the day, the value of your assets that you then pass on to your children are not reduced by the laws that we see on a daily basis. Let me stop you like that so that they will not arrest me. Thank you.
Thank you very much. Thank you, sir. So, since this program started, all the speakers have been emphatic about plan your estate, get professionals to plan your estate. In fact, get institutions to plan your estate. They have the specialized skills, they have the know-how, they have the wherewithal to do that. I am sure somewhere in the minds of most of members of the audience here is the question. So if I hand over my estate, I hand over my wealth to you, are you going to shut me out? Will I be shut out from the day-to-day decisions on how the estate is managed? How do I get to know how much you are making? Can I trust the figures you are giving me? Can I trust that these assets will actually be preserved in value? These are very real questions that people will always want to ask, particularly when you are asking them to hand over their wealth, their assets, which they have labored very hard for, to get. So, as institutional players, I'll throw this question to Mr. Ismail and Mr. Obendege. Are there assurances, are there institutional assurances that when this happens, when they give you their wealth, when they invite you to plan and manage their estate, they can be rest assured that it is not just, an institution is in charge of it, but that it is actually properly done and financially secured. Mr. Ismail, start with you.
I think the first stage is, the first condition for such kind of investment is to consider preservation of capital or investment or asset, as the case may be. So meaning you have to factor in that the asset or underlying assets in which this wealth will be invested in will be those low risk portfolios, be it fixed income like school or other real estate projects that are well documented. So I think you have to factor in the risk profile and ensure that, number one, those assets are well preserved, because it is when you have the asset preserved that it cannot be subjected to inheritance or any form of welfare package. Then the second one is, because they are regulated entities, you have less risk of maybe one family member or an individual diverting this fund to their own benefit. So if, for instance, you have a investment with either or first trustees, irrespective of the relationship manager in this company, the institution still remains. So meaning they will treat you like an institution the privacy of your investment should be well protected in such a way that one of your heirs may not be leading to assassination for them to quickly get the benefit of some of these assets. And again, they will also provide you that KYC, which is also very key. If you have people who have investments, they change emails, they change phone numbers, even when they are late, especially for those on the digital asset part, you may not even be able to recover those assets. So, but when you have institutional advice on managing this, the framework will already be well documented and provided that it makes the succession very easy and there won't be much issue as such. Then lastly, what Mr. Rotimi was saying about tax, which is part of the liability that may deplete the investment fund itself. So when you give those funds to a professional financial advisor, all tax-related issues will be well handled. And for those whose wealth is also zakatable, they will be able to also advise you on the payment of zakat on an annual basis. Then lastly, for institution, for us that we do investment, there may be purification of income that comes into your investment on an annual basis. So if a financial institution who understands the Sharia principles manages your investment, purification can be done at that end in such a way that all what comes to you becomes halal income, so there won't be impermissible income as part of your total wealth. But when you do it individually, nobody will be able to advise you whether the income you earn is actually Sharia compliant or not. So it gives you that what you are spending is 100% Sharia compliant. Thank you very much.
Okay, so let me just quickly say this. So I said that in a trust arrangement, for example, there are three parties, core parties. The person creating the trust, which is you. The institution managing the trust, which is Al-Amin and First Trustees, and then the beneficiaries. What gives you the protection is that there is a fourth party. That fourth party is known as the trust protector. It is your responsibility to decide who the trust protector is. Now, in deciding who the trust protector is, you can pick individuals or you can pick an institution. So, for example, you can pick a law firm. What has that done to you? You have then said to yourself that instead of me picking an individual that may be compromised or an individual that will not last or live as long as a trust company, I picked a law firm and it's your sure that from one partner I can move to another partner and another partner. What that does is that when the trustee starts to misbehave, they will first report that trust company to SEC. Trust me, SEC these days does not play. The first thing they will do before they listen to the trustee, they will first give them one small letter, love letter, which is most likely going to be a fine. Then they will now hear what you are saying. By the time they finish the case, by the time they find the trustee a second fine or maybe a third fine, the trustee will calculate the income they have made from your estate and calculate the fine that the SEC has fined them. Then realize that it's not worth it. That keeps the trust company in check. So at First Trustees and at Al-Amin, I can assure you that because of that fear, we are not even talking about a second level fear where you can then decide to go to court if you are not satisfied. What that means is that if you get a very, very good lawyer, the trust company will pay for the legal advice of your own, we pay for their own, and we then pay whatever expenses that the court decide that they should pay. So always think around that way. Finally, I'll just say, look at the institution. The institution will most likely tell you whether you should deal with them or not deal with them. Look at integrity. Do they have integrity? Look at how long they have stayed or they have been in the market. Look at the principal originators of the companies themselves. Do they have, in your opinion, a track record that you can trust? But above all, always make sure that you have a trust protector as part of your estate plan, because it helps to keep the trustee in check at all times. Thank you.
Thank you very much. When I asked the last question, so I was looking into the audience, there is a director from SECMED. So the moment I asked about the possibility of trustees misbehaving, he stopped frowning and he sat up straight. Okay, so this brings us to the end of our conversation. But before we go, we'll take a couple of questions from members of the audience, very briefly. Just, okay. Like I said, okay, please pass the mic to this way. Just straight down there. The man on the car, straight down. Thank you. Straight down. Straight down, straight down. Yes. Thank you.
Thank you very much. Assalamu alaikum warahmatullah. It's not that the moderator has put me on the spot as a director from SEC. I think just for me to just make one or two comments. One is about the issue raised by the last speaker, the protector that he mentioned. I think it is important to state that aside from the SEC being the one oversighting the trustees' business in Nigeria, I think even the trustees themselves, we have other mechanisms which I think are being embedded. One, for the trustee to even operate as a corporate trustee in Nigeria, you need to have this, what we call sponsored individuals that are actually even registered. So I'm just going to emphasize about this issue about protection. There is an internal mechanism by even the trustees entities having the right people registered as sponsored individuals to be able to actually do that function. And again, I really want to talk very interesting topic about informal investment, digital asset and fintech, which I think the presenter made a very excellent presentation. I think for corporate trustee it's a challenge, and I think the challenge is for all of us to find a way to build internal capacity in terms of valuation of this digital asset. It's a big challenge, even for us as regulators. So for corporate trustees, and when we're talking about Sharia compliant crypto digital asset, we need to have a very good mechanism to be able to make this valuation, whether it is a market valuation or daily valuation. I think it's something that I believe we need to have to think about that. For us as regulators, it's an area that really gives us a certain kind of concern. And I think it's not only just for us as regulators, even the players, when you have clients and they have this digital asset, how do you value it? How do you value it? Do you have a kind of mechanism to do this valuation? Or do we need to maintain a kind of mark-to-market on a daily basis to be able to say, okay, if the person dies, for instance, and you have costs to now distribute out to the heirs, how do you go about making this kind of distribution in an equitable way? I think it's really something that we need to think about. We may not have the answer here, but I think it's something that we need to ponder and be able to really have a very good framework for making this valuation. The other issue is about this password. I think somebody talked about password. And really, it's really something that for corporate trustees, because if you have the password, these password keys for the crypto assets, for instance, is it something that you can be able to have somebody as a custodian to now keep that key password key in the event of eventuality, so that at least you can have a kind of separation between you as a trustee and the custodian in line with what SEC will provide. Let me just stop here, but I think it's really very interesting topic, and it's something that I think we need to really pay attention to. Thank you.
Thank you very much. The intention was not to put you on the spot, but we are very glad we heard from you. So, this way. Where's the mic? We'll come this way first. Give the mic to Ajay. Behind you, please. Behind you.
Assalamu alaikum. Thank you very much for this very insightful session. I just wanted to ask, because I think it's a basic question, what are the associated costs for doing all of this? Because that could actually deplete the profit that you make or whatever it is that you gain from investing in this kind of venture. I'm sure it doesn't come cheap to take an institution, and that will prohibit you from engaging. So I'd like some light on that.
Okay. Thank you. Sorry, let me just aggregate then. Yes. So let's bring the mic to the front. We'll just take 2 more questions because of time constraint. I apologize.
Okay, thank you very much. I have 2 questions. One is, can someone provide some elucidation on the relationship between Islamic inheritance law and the new tax regime? Because there appears to be some notion that if you probably have a trust, you may be exempted from the full rigors of the new tax regime. I don't know. So can someone provide an explanation, more explanation of that? Right. The second thing is, there appear to be, especially when Professor Fontana was speaking, there appear to be a difference between trust and waqf. I want to know if that difference, what is that difference? How are the 2 different? Thank you.
Thank you very much. So we'll take, there are 2 hands, 3. Can we aggregate the questions? 1 person there and take 1 person there. Sorry. 1 person from that table and 1 person there. Sorry, because of time constraint.
I think we cannot speak about informal investment without speaking about agriculture. Without speaking about agriculture. For context, my name is Mohammed Ibrahim. My daytime job is as the Executive Secretary and CEO of the National Agricultural Development Fund.
Thank you.
My question is largely to Islamic trustees. I think the coming of Islamic trustees provides a huge opportunity towards agricultural financing. Again, we're in a country where the NBS has reported that about 63% of Nigeria is within the poverty line. That's 133 million people. The food security situation in our country is fast abating. However, there are reports that indicate in 2026, about 30 million people will face acute hunger. Now, waqf, especially, the way we see it is that it provides us all an opportunity to merge sadaqah, social responsibility with economic regeneration. So the challenge to Islamic trustees is, 1, how can we structure waqf, some sort of a fund of funds with lower awqaf targeting critical economic situations in the country. Within the agricultural sector, the current financing gap for agriculture is estimated to be about 76 trillion naira. Public sector funding will not be able to provide for this. So the thrust is to see how public sector funding can catalyze private capital. Islamic finance products have proven to be probably the best product for Islam for financing agriculture.
Sorry, because of time, sorry.
So that's my question.
Thank you very much. Thank you. No, I'm excited that we're all interested in this session. So I'll just take 2 more questions instead of 1. So can we take...
Assalamu alaikum. Thank you very much
There's 1 person.
for this opportunity. My question...
Very quickly, please.
Yeah, my question relates to, we keep repeating about the village uncles, village aunties, and then how we need to come up with a structure that can protect us in the event of that. I was just thinking, is there any plan to extend these services to people in the rural areas? As we all know, to extend the trustee services, make it accessible to rural areas. Because
that's the question, sir.
Yes, the figures here may look big, but we all know transfer of asset and inheritance is always very costly in our rural communities. Sometimes they lead to debt. So is there any plan to make sure that these services are also extended to those village uncles and
Thank you very much. Thank you very much. The man in front of you.
Yes,
Thank you. Just a question, please.
Yes, quickly.
Yes, quickly. Just a question.
I just want to ask.
Okay.
It applies to the trust as well as what the Quran provides in regards to inheritance. Can you disinherit anybody? Okay. Those who are ordinarily entitled. Okay. Thank you.
Finally, sir. After this, please, you have a question. Just write it down so that we can attend to it later. Thank you.
Good afternoon, all. Assalamu alaikum warahmatullah. My name is Nasir Ali Sarkinoma, Head of ICT, Nigeria Agricultural Insurance Corporation. One of my questions just said by a colleague about extension. And then I was fortunate to be here, not by invitation, just to come and see Sheikh. So when I saw the Islamic estate, I said, we might play a vital role here because I'm from Nigeria Agricultural Insurance Corporation. So I don't know what the past presenters said, but firstly I have to commend the effort of the organizers, the presenters, as well as the listeners.
Thank you, sir.
And I don't know.
Yes, can we just take your question, sir?
And I don't know whether you looked into the insurance part of the estate and other properties of the maybe trustees to the companies. Thank you very much.
Thank you very much. So we'll go very quickly to the questions. And I crave your kind indulgence to be as swift, apt as possible. There was a question around valuation of assets and then the cost of procuring estate planning. Can we have a very quick response to this from Mr. Bailey?
Okay, so I'm not going to lie to you. If it's hard for the regulator to be able to value cryptocurrency and assets, think about your uncles and aunties that are in the village, how they will be able to value it. But what we do many times, and with us at First Trustees, is that we have partners. We partner with them. You see the dashboard, you value based on market value. Because if you are going to sell cryptocurrency, really, it's at the point of sale that you then think of distributing. So you will see it and you will know when and what the value comes to. But then, like I said on the lighter note, I hope he has gone. If it's hard for them, then it cannot be easy for us. The other one, so please delete. The second part now is costs. I know at First Trustees and at Al-Amin, our management fee is not based on the value of the assets themselves. They are based on the value that is created. So, for example, if we manage your assets, let's say the assets generate 2 million in a year, we will take 10% of the 2 million. So it is based on the value that we create, not on your asset. Because by the time we start to take on your asset, we have talked to your beneficiary, and we are not your beneficiary. We are just a manager of the entire trust arrangement.
Thank you very much. We'll go to our eminent Prof. Professor, can you quickly speak to the question about that was asked on the difference between trust and waqf, and then possibly also just touch on the relationship between Islamic law and the new tax law? Is there a possibility of paying less tax if you take an Islamic trust, you pay an Islamic trust or waqf?
For the last part of the question, I will leave it to the tax man, because he has taken on talking about the tax. But to respond to the difference between waqf, Islamic endowment, and trust, actually they are parallel, even though sometimes they are interwoven in Nigerian context. Waqf is done for charitable purpose and usually perpetually. And somebody dedicates a particular asset, movable or immovable or even cash or any commercial tree or economic tree that has value to particular beneficiaries, which is called Shartul Waqif, based on what he wants to be done with the proceeds of that particular asset, and it is purely for charitable purpose, not for business purpose. And the laws governing them is the Islamic law, and even within the Nigerian context, the law governing it is the provisions of the Constitution under Section 272 to 75, what talks about the Islamic personal law. So also other state laws that govern Islamic personal laws, inheritance, waqf, wasiya, and the likes. When you talk of trust, it is part of what is tagged usually as received English law, under what is known as the doctrine of equity, where trust is being created, and it is arrangement between the beneficiary and the trustee. While the trustee is the legal owner, the beneficiary has the equitable right in that trust. And it can be used for charitable and sometimes not charitable. It's just a delegation of power to be used as the corporate trustees used to do it. Let me give an example of the federal government sukuk that is being issued and the other ones. Usually, SPB is being represented by the corporate trustees, and they are to carry out the powers of the SPV on behalf of them. It's not a charitable arrangement, it's a purely business arrangement. But then the nexus is that sometimes in Nigerian context, we use work through corporate trustees or incorporated trustees as provided by the KAMA section 826, 2020. So this is the nexus between the trust and the work, but they are typically parallel. But if work is being created under the supervision of a trust, that is of a trustee, that trustee only serves as Nadirul Waqfi or Mutawalli Waqfi, which is the superintendent or supervisor of the work as enshrined in Sharia. Wallahu a'lam wa a'lam.
Thank you very much, Prof. Like they used to give us a very simple example. So, okay, tax. Okay.
Okay. My guy is here, so I have to mind what I'm saying now. Okay. You have 100 million, you give it to an asset management firm, they manage it for you, they generate 20 million as income or profit, Sharia compliant investment as profit. The government will tax the 20 million. You then decide that this is my 100 million, I want to create a trust. Then say in your trust deed, this trust will do A, B, C, D, which will include provide education, provide benefits or welfare for my mom, take care of her medical bills, create an HMO scheme for her. All of those expenses plus the one you will pay me as your advisor. Out of the 20 million, your trustee will provide and calculate all of the expenses and then say that we spent 13 million in doing all of this in a particular year. How much will my tax be? 20 minus 13. I'll pay a tax on 7 million. The new tax law is specific in terms of how they will recognize the expenses. It has to be based on the object of the trust. What is the trust supposed to do? If it is not there in the trust deed, they will not allow it. But if it's there in the trust deed, it becomes allowable expenses because the trust is managing the entire affairs. Same thing is when you have an estate and when you decide to write a will, it is important that if you're generational, you're wanted, for example, you then say, let these executors manage it. Don't just leave it like the executors should manage it and that's all. You then have to instruct the executors what they will do with the money or with the value that will be created from the assets. Once you put those clauses, the executors will carry out those clauses. let me use, even though this one is old, and please just permit me, let me use it. For example, Ganifa Wemi's will, even though it's conventional, it can also apply. Everything is just about structure. There's provision for scholarship. Scholarship becomes what? Expenses. There's provision for monthly allowances for his wives. It becomes what? Expenses. There is provision for remembrance ceremony for his dad during his dad's birthday and for his own too. What did he say they should do? Feed beggars, feed the poor. And we upload all of this as part of the expenses to the estate before I think about paying tax. Am I going to pay tax? Yes. Will I pay as much as I should pay? Now you go answer that one.
Thank you very much. So lastly, before we close, we are sorry we have short our time by 5 minutes now. We are rounding up now. Mr. Ismail, the last question, the last two questions basically borders around using WACF, right, for developmental funding, like agriculture, and and the other person asks, are there insurance components to this trust creation or work management? Very quickly, we can answer this question.
I think for work, it will not depend on the form of agriculture that we are looking at. Is it for cash crop cultivation, whereby it stays for a longer period because the work needs to stay for a longer period? Or is it for crops that can be subjected to some risk, which now comes with the TACAFU being provided? Yes, TACAFU cover can come to come and provide that loss that may happen during the cultivation year. But the major thing is we have to factor in those agricultural financing that will preserve the capital being invested itself, so that the trees that we planted do not become falling and the asset has gone as such, meaning there is no work asset at that point. Then the other question on the maybe bringing in the informal sector, like you mentioned, that this gathering should not just be made to maybe the HNIs, that we also need to take it to the interland. I think I totally align with you. And I think the modus is just for us to have that understanding with the traditional religious institution who have direct contact with the local people. And we also need to probably maybe adopt the same format the fintech people adopted. They use the same local traders to operate accounts so that people can come there and open those tier 1 account that allows them to bank. So now we see that the number of the unbanked population is increasing. However, in the capital market, it is not the same, because for you to have investment in the capital market, automatically it shows that you must have investment, it must have a bank account. For people who already do not have bank accounts, these are secondary services like trust services. It will be difficult for some of them to be onboarded in this manner. So I think the major thing is for us to change, also adopt some format, go into some of these informal sectors, especially the cooperative, encourage people to register their assets, have documentation, because that is the first stage, have the KYC. After that, then we can now be thinking of how this work can be passed from generation to generation. Thank you very much.
Thank you very much. And with this, we come to the end of this panel. Yes. Okay, Prof. Professor, please, can you quickly answer that? Then can we disinherit? Is it possible to disinherit a person who is a legal heir under Islamic structure, under Islamic law of succession?
Actually, inheritance is being designed by Allah subhanahu wa ta'ala. So no one has any legal rights Islamically to disinherit somebody, except if there is any impediment to inheritance. And these impediments are also established by Sharia. There are so many impediments to inheritance, one of which includes One, if somebody is found guilty of committing homicide against the person, that is the deceased person, if he is found guilty of this termed him or stopped him from inheriting, based on the general rule that man ista'jala shay'an qabla awanihi uqiba bihirmani. Whoever tries to fast track things that if he patiently waits, he is going to inherit, then Sharia will stop him from benefiting from that. It will also include the impediments. The impediments also includes difference in religion. A non-Muslim cannot inherit from Muslim and vice versa. So also one of the impediments also is when there is concurrent death. If somebody dies or two persons who are to inherit one another, if they die at the same time, this one will also, none of them will inherit one another, and there are many more, except within these exclusions. An heir is not allowed to exclude any of his, a deceased person before his death, of course, cannot exclude anyone from his inheritance. Wallahu a'lam.
Thank you very much. With this, I'm sorry we have come to the end of our panel. I thank you for being a very engaging audience. And if you have further questions, you can just write them or we'll pass them to the panelists. Thank you very much to our eminent discussants and panel. Thank you, Professor. Thank you, Mr. Thank you, Ismail. Thank you very much.